Hello, everyone, and welcome to today's webinar, Top 10 List for Delaware Community Associations, Part 2. This webinar is Part 2 of our two-part series. Before we get started, I would like to go over a few items so you all know how to participate in today's event. You've joined the presentation listening using your computer speaker system by default. If you would prefer to join over the telephone, just select Telephone on your webinar control panel, and your dial-in information will be displayed. You will have the opportunity to submit text questions to today's presenters by typing your questions into the questions section of your control panel. A quick reminder that if your control panel does close up, simply click on the small orange arrow to open it up again. I would now like to introduce our presenter, Chad Toms, attorney at Whiteford, Taylor, and Preston. Chad?
Thanks, Ryan. And I want to thank the board members that have come and joined us in person today, and anybody else that's listening online. This is section or part 2 of what we put together as our top 10 issues for Delaware community associations. And so just by way of a brief reminder, why we put this together is these are the top topics or top questions that we get all the time, and we thought it might make sense to just discuss them from a general perspective for our association clients to kind of give you a little bit of direction on how things are typically handled, and hopefully it can give you some guidance. So we'll address questions either from the folks here in person or being typed into the screen, hopefully, as we go. And the topics that we have for today are 6 through 10. And so I'll just jump right into them and get started. So item number 6 is how do we go about amending bylaws and adopting rules? So I often get questions from community associations that go, well, how do we adopt our rules? Do we have to give notice of them first? Do we have to adopt the rules, then send them out? Then what happens if somebody has a question? So interestingly enough, the landscape is not super clear in Delaware because if you were a pre-existing condominium community, some of the language would have allowed a different process than what we recommend as best practice. So let's start there. So which comes first? Do I have to give the adoption or the notice first? Well, if you're a pre-existing condominium community, the Unit Property Act in Section 2207 and 2211 allows the Board of Directors to essentially be the first action. So the Board of Directors can adopt rules, and believe it or not, they can actually amend the Code of Regulations the same way, so amend the bylaws by essentially the board taking the action. Then what happens is the board has to then give notice of that to owners, and those actions or those rules essentially are deemed ratified or become effective, and here's the catch. Unless a majority of unit owners call a special meeting to change the rule. So essentially what happens, that puts all the power with the board of directors to kind of just force new rules and new changes onto their associations. Well, believe it or not, the new statute takes a different approach. And so what that means is it kind of upends that process. It takes an opposite approach. And essentially in Section 303 and 306 of the Kiowa statute, what has to happen is you add the bottom section there too. It requires that the board of directors gives notice to owners of their intention to adopt a rule. And then essentially what has to happen is there has to be a notice of a meeting for the owners to show up and give the board of directors comments on what's being proposed to be changed. So essentially recognizing you have two opposite processes there. So if you're an older condominium, most of the power sits with the board of directors. If you're a newer condominium or a association that now is subject to the Kiowa statute, you want to send draft rules out ahead of time for discussion purposes and to receive comment on. And just so that you know, what we recommend as best practices is the Kiowa statute, meaning you don't want to create an adversarial relationship between your owners and the board of directors, so it's often best to get those draft rules out for people to look at and to consider before they're adopted, so that if there really is opposition or controversy or the way that they're written, you can take those comments and edit them before you move forward with an adoption. So while we're on the rules, it probably makes sense to hit some of the specialty topics under Kiowa. So there's a rule that relates to ARC applications. So a lot of communities have a process by which owners have to seek architectural approval before an owner can begin to make modifications to their structures. So under the Kiowa statute, there's a requirement that if there is such a process, that there has to be an application, and here's that other word, reasonable timeframes. So you can't require that the application be done in a very short time period. Instead, the court provides reasonable timeframes for the submissions and also for the responses. Believe it or not, there's also a specific rule related to flags and signs as well. And then related to that, there was an amendment to the Delaware statute not too long ago that addressed flagpoles. So if you're wrestling with a flag issue or a flagpole issue, we would strongly encourage you to consult counsel, or at a minimum, go look at the statutory provisions addressing those things. And the one final thing to think about when it comes to rules is the statute requires that they always be reasonable. Reasonable is not defined in the code. So what will happen at the end of the day is if someone challenges a rule as unreasonable, we'll ultimately end up in front of a judge in a court of law, and the court will determine what's reasonable in that regard. So that's it for adopting rules. I'm going to move on now to what is our seventh topic, insurance. I talk about insurance all the time. So the slides that we're going to go through are going to be primarily focused on condominiums because condominiums have one of the more complex structure as to requirements and how they're handled. However, if you're watching the webinar and you're in an HOA, there are still requirements related to HOA too, and I'll try to make some of those distinctions as we go through those. So here's kind of the topics that we're going to break up for insurance, meaning what obligations does the association have to purchase insurance? How do we handle deductibles? How do we manage the claims? And is there a duty to manage the proceeds? And these are the type of topics that we talk about all the time when communities start to deal with claims under their insurance policy. So let's start with the obligation to purchase. So a community's governing documents, as well as the state law, will impose certain minimum types of insurance that must be acquired. So for my HOA clients, there's nothing in the statute that requires an HOA to obtain insurance, but more likely than not, your governing documents are going to require you to purchase some type of liability insurance, property insurance, and we're going to talk about some of the other insurances that you may want to consider anyway. But failing that, if you're a condominium, there's a statutory provision that we'll get into in a little bit, and more likely than not, your governing documents have a very specific type of policy that you have to acquire. So the point that we're making in this slide is that when it comes to condominiums, there's a number of different types of policies. We call them either a bare wall type of policy, an as-built policy, or a betterment and improvement policy. And what that really means is the association is typically required to purchase a master insurance policy. And the master insurance policy actually covers portions of owners' units. But the question is how much of that unit gets covered? I mentioned bare walls. Well, as you might expect, that term bare walls just means the bare walls, which means if there's a fire or a flood, the association is not putting the kitchen countertops back in or the kitchen cabinets back in or fixtures. They're really just putting the drywall back in place. The second level of insurance, and you have to look at your documents if you're required to purchase what's called as-built, which means as the condominium was originally constructed. So in that particular case, the insurance should put the unit back to as the builder originally constructed it, meaning that would be your kitchen countertops as constructed, your cabinets as constructed, your fixtures as constructed, which that's fine for a condominium that's fairly new because the techniques and the building process and materials are very similar. But if you're dealing with a condominium from the 70s or the 80s, you might not want to put back to as it was built because of all the last policy, betterments and improvements. So there are some policies out there that require an association to purchase a policy that would put the units back to their condition before the casualty. That's called betterments and improvements. So if I upgraded my cabinets, if I upgraded my flooring, if I upgraded my countertop to granite, that type of policy would require the association to put the unit back to the condition in which it was previous to the casualty occurring. Now, let's take that last policy. Those are very difficult to manage because from time to time, you have to figure out what's in people's units so that you can adequately insure it. But the point being, if your governing documents require you to purchase that type of insurance, you need to know, am I getting the right type of coverage for the right type of policy based on what I'm required to do? And if you fail to get the right policy and the insurance proceeds are inadequate, someone can take a position that the association is responsible. All right, so let me jump into some of the slides to give you some of the specific references in the Delaware state statutes that kind of link you to where your obligations are to purchase insurance. Old condos, let's start there. The Unit Property Act. Section 2238 only requires the board of the association to purchase the insurance that's required in the governing documents. Okay, so that's not very detailed in the statute, right? So what happens there is you have to go to your governing documents. Most governing documents in a condominium will be specific as to what's required, but some are not. But that really sends you back to your governing documents. Not very specific. But let's jump to the new statute, the Iowa statute. So Iowa is a bit more specific. So in section 313, it requires property insurance of not less than 80% of the actual cash value of the insured property. So this is not a bare walls policy. So if you are born today as a condominium, the Iowa statute is requiring you to get this exact type of policy, which is the actual cash value. So just keep that one in mind. What else does the Iowa statute require you to get? It requires you to get liability insurance, and here's the catch, in an amount to be determined by the board, but not less than an amount specified in your documents, okay? So I know we all want clarity. We want the statute to say $1 million or $2 million or $3 million, but that's not the way it works. So what happens is the board has to go to their documents. Is a number specified? And rarely it is. Thus, you end up back to the board of directors trying to decide what is the proper amount of liability insurance. And it'll typically change community to community based on the activities you have. If you have a pool in your community that is run by the association, you probably would like a higher level of insurance than if you have no pool. So those are the things that your board has to consider when determining that. Finally, fidelity insurance is required. But now keep in mind, this section 313 is not applicable to pre-existing communities. So that fidelity insurance requirement, if you existed prior to 2009, you're not required by the statute to purchase fidelity insurance. And just to make sure everyone that's listening knows, fidelity insurance is dealing with theft or loss of your assets or resources. You'll typically get that for whoever's handling the money aspects of your association. So that's what's required. Let's talk a little bit about what's not required that a lot of associations purchase anyway. And the first one, D&O insurance. I know it's a shocker that that wasn't listed as a requirement in the statute, and I rarely see it in governing documents, but most community associations choose to purchase D&O insurance, which will cover the directors and officers when they're sued in their individual capacity for breaches of fiduciary duty. Sadly, it happens, as we say at our seminars all the time, us lawyers, well, we need something to do from time to time, so somebody must sue somebody once in a while because we have to eat also. So these types of lawsuits do happen, and the D&O insurance is usually the best way to manage that. So if you don't have D&O insurance, we would encourage you to speak with your broker to determine if you should have it and what the cost of that might be. And then finally, one that we deal with all the time for our resort communities are wind and hail policies. Those are usually on top of and separate and apart from just your general liability policies, because if anyone's ever taken the chance to actually read through their insurance policy, they'll see a ton of exclusions. Wind and hail is almost always excluded in those types of policies, so we always encourage you to consider if you want these types of policies, you should get them as an add-on. Okay, so let's talk a little bit now about deductibles. And just so that you know, I spend a lot of time amending governing documents to address deductibles. And again, this is primarily a condominium issue, not so much an HOA issue, because the condominium is purchasing an insurance policy that covers the person's unit, and so therefore now we start to deal with the deductibles. Who pays it? Neither the UPA or the Iowa statute mentions the treatment of deductibles, and I've rarely seen it in a set of governing documents. However, Maryland statute addresses it specifically and has an amount and how it should be done. So as a result, here in Delaware, I see a lot of communities that are amending their governing documents. Why are they doing that? Well, they're doing that because they're putting really large deductibles in place. $25,000 deductible, $30,000 deductibles. And the question becomes, who pays that deductible? When the deductible was $2,000 or $2,500, when an event or a flood or casualty would occur, it's not that difficult to go through and have the association pay that as a common expense. But once we start talking about a $25,000 deductible, we have some real concerns about who should pay that deductible when somebody caused or allowed that casualty to occur. So for example, if I didn't change the water lines going to my washing machine and they were 20 years old and they burst, who should pay that $25,000 deductible? Is it me, the homeowner, that knowingly left those old lines in place? Or should all the owners in the community pay? So that's the reason why we're starting to see some of those things. So how, if your community was going to address deductibles, how would they do it? Here's the three most common ways that we're seeing those changes being done. You would allocate the deductible either negligent or causation, meaning who was negligent or who caused the issue. So let's take my water line example to the washing machine. We would be arguing that owner is negligent or responsible. Now, there's a downside to this, is we have to prove negligence or causation. Sometimes we, the association, are not in a position to know who did what and why they did it. We have suspicions, but to be able to prove it, that's problematic. What's one of the other options? Receipt of the insurance proceeds. So we can say, well, whoever got the money to fix their unit pays the deductible. There's a certain amount of fairness in that. But the problem is, imagine if that person with the water line that broke was actually on the 5th floor. They received very little damage, but the people on the 4th floor, 3rd floor, and 2nd floor, who really weren't at fault, received most of the damage. Why should they have to pay the deductible? And what's the third option? This is the most common one that we see, is where did the casualty originate? I mean, where did it transpire? So if the casualty occurred in Unit 201, regardless of cause, regardless of who has to bear the brunt of the damage, that's the unit that pays for the deductible. So that's the most common technique that we're seeing for condominiums that are amending their documents. So let's talk now a little bit about managing the casualty. Most of the governing documents of an association will impose obligations on an association to take the insurance claims and manage the process, which would be to get bid and coordinate rebuilding services. So when you took your job on the board, did you know that you were going to be a project manager, where you had to go out and meet with the contractors and decide what bids to get and which contractors to select and how to spend the money? Well, that is an obligation that's often on the board of directors. Now, most of the time, if you have professional management, the associations will be offloading that responsibility to their management company, but you do have to understand it is the association's responsibility to make it happen. The association just takes the insurance money and hands it off to its owner. You've got a problem. If that money doesn't get spent the right way, you've violated your documents and not followed those procedures. So where does that take us? Well, there's some triggering events in the governing documents about when the insurance proceeds are to be spent, and we start to do an analysis of, well, what got damaged? Is it a common element? Is it a unit element? Which gets paid first? And that sends us always back to our governing documents to address. So you have to be aware that your provisions in your governing documents will address what happens when your insurance proceeds are just not adequate to cover the actual damage. Okay. So what happens now that I have the insurance money? I got a check from the insurance company. What happens? Well, back to our governing documents. There's lots of obligations in there sometimes that address how we're going to handle the insurance proceeds. So oftentimes there's a dollar threshold in the governing documents that require the use of an insurance trustee. So if your insurance money comes in at a certain dollar amount, you shouldn't just drop it into the general fund of the association. Oftentimes what you'll do is designate an insurance trustee to manage the funds. And essentially what they'll be is establishing a process for receipt of claims, paying out to contractors, and making sure that the contractors are not billing beyond where your insurance proceeds and the estimates are, and that's the job of the insurance trustee. The insurance trustee will often charge a fee for their services, and typically, in my experience, the insurance company will provide for the fee of the insurance trustee as well. So something to be aware of. You want to make sure that you follow that. You can put the next one up, because if you fail to follow that, it's a strict violation of your governing document. So what I've seen is, in the haste to get things reconstructed, we make the insurance proceeds available to the contractors as quick as possible. And at the end of the project, there's not enough money to go around, and then we start fighting about who should have been paid versus who actually got paid. And the benefit of having the insurance trustee is hopefully those issues are addressed well in advance. Be aware that when the insurance money comes in the door, is it going to go to the insurance trustee? Like, should the association accept it, or should it be placed in trust? Something to keep in mind. So that's insurance. Now, insurance was one of our biggest slides, so hopefully I didn't overstay too much of my time. One of the other things that I constantly find myself telling associations is be careful about assumed duties and assumed risks. So in a nutshell, if you take on something that you're not obligated to do, that's where this comes in. So very few governing documents impose upon the governing body, the board of directors, or the associations, the obligation to protect a person or their property, right? So I often see security committees, I'll see neighborhood watch, I'll see a lot of activities that the association undertakes which are designed to protect an owner's person or their property. Rarely will you ever see a governing document that placed that obligation on a community association to do it. Instead, those duties typically will rest with a governmental body, your policing authority. So say, for example, an evacuation plan may have been adopted, but again, that's for your emergency medical agencies to have developed those types of things. However, associations take these on all the time, these quasi-governmental tasks such as the security and the evacuation plans. So what does that mean? Well, in that situation, the association has now chosen to undertake an obligation or assume a duty that they didn't have to do before. What does that do? Now you step into a negligence standard. So that means if you're going to choose to voluntarily do something you didn't have to do, the law says you better do it right. And in that particular case, now what we're saying is if you choose to do these things, like put a neighborhood watch or a security committee in place, you have to do it right. Well, what does doing it right look like? Well, it's not a statutory provision, but you can see from case law around the country the types of things that aren't. So you think back to the Trayvon Martin case where the security individual was armed. And when a person gets injured by one of those folks, the question becomes, did the association have liability to make sure that their security folks had appropriate background checks, that they weren't armed, or worse, that they weren't, consuming alcohol during the process, using equipment like for golf carts at excessive speed. Those are the types of things that you have to start thinking about. So once I take on that task, you have to make sure that you do that task right. And so what we always say is consider the task, and if you choose to take it on, you have to also analyze and manage your risks appropriately. Make sure that you're managing it through insurance. Do you have the right insurance in place? And then are you putting the right procedures in place to make sure that you're not overly exposing the association to risk? So that's one of the concepts we talk about a lot with our community associations. Okay, that brings me to item number 9 that I spend a lot of time talking about. That's internal dispute resolution procedures. In Delaware, we have a common interest ombudsman, so the Delaware Common Interest Community Ombudsperson. And what that person does is receive complaints either from owners from owners about actions of the board of directors, and that can go the other way. The boards of directors can submit complaints about owners, but it's a statutorily created provision that has a process for which the creation of an internal dispute resolution procedure. That statute, if you want to take a look at it, can be found in Title 29 at Chapter 25. The current ombudsman, that's Mr. Chris Curtin, interprets the statute as requiring that all common interest communities in the state of Delaware adopt some form of an internal dispute resolution procedure. The ombudsman has developed a sample that's available on his website, the Attorney General's website. I think I have a slide here that'll show you where. It's not exactly super easy to find on his website. So this is the website. When you go to the bottom, there's helpful resources. And then if you'll see where we have the arrow, you can click on the Ombudsman template, internal dispute resolution procedures, and that will give you the Ombudsman sample. Okay, so the Ombudsman takes a position that if an association has not adopted their own version of an IDR template, then the one on the Ombudsman website will control and has to be used. So as a result of that, I recommend that associations adopt their own versions. Most of the time, I recommend you adopt some version that looks very similar to the sample, but maybe changes some of the time frames to make it easier to comply with, or make it a little bit more friendly to the association. But the point to be taken away from that is that in Delaware, every common interest community should be adopting an internal dispute resolution procedure. So what should you put in it? So these are some of the kinds of things you should see in your internal dispute resolution procedures. One, we recommend requiring all complaints to be in writing. You don't want to deal with telephone calls or anonymous tips. So preferably create a form for the submission of those complaints and require that owners use that form. Then have written procedures for the process. We recommend that you have a process by which that you acknowledge receipt of the complaint so that you know the date by which the association received it. Require that documentation be provided with the complaint. And that's one of those things where the documentation may require that the complaining party specifically identify what it is that they think the board did wrong, meaning what governing document did I violate, what statute did I violate, be very specific. There also in the IDR procedures, there should be an opportunity for the association to request kind of follow-up information, meaning, answer these types of questions or provide these types of documents. The IDR should also have a consideration for the complaint by the board, meaning we're going to have a time period when the board will either at a regularly scheduled meeting or a specially scheduled meeting address the IDR, and then there would be a written notice of determination on the IDR, and essentially what that format should look like. So these are the kinds of things that you should put in an IDR complaint. So what my recommendation is to common interest communities is to develop this process, but leave some flexibility in there, because not every IDR is the same. So if a particular complaint comes in about the way the election ran, that's a very formal process. What do the documents require? But then you could also receive an IDR complaint about just neighbors not getting along with each other, and that would be handled in a very different way. So I encourage some sort of flexibility in the process, giving the board discretion on how to deal with these types of things, and address them either in person or at hearings. So that's it for the internal dispute resolution procedure, and that brings me to my last and final topic, which is fair housing. This is not a Delaware-specific topic, but it is a topic I find myself talking to associations about a lot. Okay, so fair housing prohibits discrimination. It just prohibits discrimination based upon a class of individual people. It also prohibits discrimination by a disparate treatment or a disparate impact. So a disparate treatment is essentially affecting a particular person differently than others in the community. And then the disparate impact is a little bit different, meaning this is the situation where a rule may look neutral on its face but have the effect of discriminating against a protected class. And I'll just give you kind of a classic example of that is if you have certain rules prohibiting children or people under the certain age from your pool during certain hours, you've essentially applied a rule that has a disparate impact on families with children. And so those are the kinds of examples of what the Fair Housing Act would prohibit from doing. In Delaware, and here's where we get to the Delaware specific component of it, we have a lot of protected classes. When I say a lot, meaning compared to some states, we have far more protected classes than others. So I've put them across the screen here. I don't think today's seminar was intended to go into all of these protected classes, but you just have to be aware there's more than just race, color, and creed and sex. There's a couple other ones in Delaware you got to be aware of. All right, so what happens in a typical fair housing type of complaint? Well, we talk in terms of the association being required to make either a reasonable accommodation or a reasonable modification. And so let me define these two terms because it'll help you understand what happens in those situations. So in a reasonable accommodation, that is an exception to your rule, meaning I'm going to change my rule, change my regulation, change my policy or my service so that a disabled person will have an equal opportunity to use and enjoy housing and does not constitute an undue burden. So I'll give you an example from an HOA. So for example, maybe an HOA has a situation where they prohibit trampolines or some sort of exercise equipment being visible from the street. In a particular fair housing, there could be a disabled child that has asked for permission to have a particular piece of equipment or exercise equipment. While visible from the street, it's necessary for their therapeutic treatment. Fair housing would require an accommodation in this situation, which is that the association would accommodate that individual by allowing the rule, an exception to the rule, means that the rule would not apply to prohibit that, and allow that particular family to have that piece of equipment visible from the street for that disabled child. And that's what we would call a reasonable accommodation. So you're accommodating a rule. Now let's modify that to get to reasonable modification. This is a different term. A modification is actually a modification to an existing dwelling or common element. Think of this as your structure. I mean, I'm actually changing the physical aspects of something. So if you have a clubhouse and your clubhouse has no ramp, but you have a homeowner in a wheelchair that needs to get into the clubhouse, they could ask you to accommodate them by allowing a ramp to be installed on the building. That's what we call a modification. So essentially, going back to those two distinctions, accommodation is a rule or a regulation. It doesn't cost me anything. I'm just allowing an exception. A modification is a change to the structure. Somebody's going to go out there and swing a hammer and do something. So where's the big difference come in? Well, in a modification, an association is typically obligated to allow this to happen, but the cost is borne by the owner that's requesting the accommodation. And this is That's the big important distinction. And what we're going to want to say is this is where fair housing and the ADA differ from each other. I often hear people say, well, under the Americans with Disability Act, you have to accommodate me by putting a ramp on the building. So I'm making the assumption for purposes of this webinar that the ADA does not apply to your community. The ADA does not apply to most communities unless you invite the public to come do business with you. But the ADA also requires modifications to buildings to allow people to access them. The only difference is the ADA imposes upon the landowner the obligation to make the modification. Here under fair housing, the cost, that's the big distinction here, is the owner has to pay the cost. So if the owner wants a ramp to get into the clubhouse, the owner has to pay the cost to put the ramp onto the clubhouse. That's the difference in the accommodation and modification. So let me just talk about some of the most common places where you're going to bump your head into fair housing issue. Pet policies. Particularly those that may prohibit certain breeds of dogs or to all animals in general, no cats in condo buildings. So what you're going to see is service animals and emotional support animals. So we've done other seminars in the past about service animals and those types of things. So we could fill an hour talking about what a service animal is versus an emotional support animal. But if you see those terms, you know you're in the world of fair housing. Use of the common element. Pool rules and parking rules are some of the most common things that we see where people are asking for accommodations, mainly accommodations, not so much modifications, but accommodations to where the parking is located, what the hours of the pool are, who can use them. But you'll typically get a lot of those things when you're dealing with the pools and the parking. Finally, the last couple categories are religion, racial discrimination, or other claims of discrimination outside the act. So these are the kinds of things that when you start to see those terms thrown around, be aware that you're in the world of fair housing. So while we're in the fair housing, HUD put out some regulations a number of years ago where they defined hostile housing environment. So we're going to talk about that a little bit. In the pre-2017 time period, we used to say when neighbor versus neighbor are fighting with each other and it's unrelated to the association itself, it's a neighbor-to-neighbor dispute, association, keep out of it. Well, HUD has said not true in all cases. If there's a hostile housing environment, there are certain situations where the association does have an obligation to get involved. And that has been defined as when there's been unwelcome conduct that is sufficiently severe or pervasive as to interfere with the ability, sale, rent, or use of enjoyment of a dwelling. So essentially what we're saying to owners now is, if you think that you have a neighbor-to-neighbor dispute, stop for a second and decide, do we have what's called a hostile environmental harassment type of case, which essentially is dealing with somebody in a protected class. So what we're looking for is one of those neighbors in a protected class, is there other neighbor picking on them potentially because of that status? And if so, we may be in a situation where there's a hostile environment, and thus the association may have some obligation to act. So what we say is look for it. So here's kind of the things to take a look for. The standard is what are the totality of the circumstances, and it's from the perspective of a reasonable person. So what we're saying to our association is kind of, if you got a problem like this, a neighbor versus neighbor dispute, don't just write it off completely. Dig into it a little bit, see if you can figure out what the situation is, because you may have some obligation to act. And remember, this is to a reasonable person standard, which is not easily defined. So you probably want to err on the side of caution when you run across those types of situations. So that's it for the last part 2 of our top 10. I think, Ryan, if you're still there, if you could open it up for questions.
We're now going to begin answering questions submitted during today's presentation. As a reminder, you can still submit questions through the questions portion on your control panel. Let me go ahead and send this first question over.
And are there any questions in the room while the questions started coming on, gentlemen?
Okay, we do have one question in the box, and it is, if the HOA allows for rental of the clubhouse for events, would ADA apply?
Okay, so that's actually a good question. It's related to what we talked about. So in general, the answer is yes, but let me give you a little bit more of a definition there. So the ADA applies to all places of public accommodation, and that term is defined generally as any area in which the public has been invited to come and visit or to come and conduct business. So if the association has a clubhouse and they choose to rent it out they very well could be a place of accommodation based upon who they invite to rent it out. So if it's only an owner that can rent out the clubhouse, typically that would not trigger the ADA. But if we open our clubhouse to anyone from the public that wants to have a wedding at our clubhouse or rent it as a fundraiser for a political event, and I don't have to live in the community to rent the clubhouse, I'm triggering what's considered a place of public accommodation, and therefore the ADA would apply. And just to warn you, the kinds of things that trip up communities all the time are we are letting the swim club use our pool for their swim meet or swim practice. We are going to have a craft fair in the clubhouse and invite craft vendors to sell their wares. These are the types of things that trip up an association where they don't really know that they've now invited the public into their facility. But what does that mean? All it really means is your facility now has to be compliant with the ADA. Now, your facility, if it's new, might very well be compliant. It may have the ramps, it may have the right, what we call the path of travel, it may have the requisite amount of parking spaces, it may have all the right grab handles in the bathrooms, it may have the right access points to all the pools. But you probably don't know that until you have an ADA expert come out and do a survey of your community. So if your property is compliant, you probably have nothing to worry about. The only thing you want to worry about is just make sure that if your property is not compliant, I don't want to become a place of public accommodation, which would then obligate me to become compliant. All right, so I have a question that came in. It says, can an HOA ever be dissolved or separated into 2 or 3 sections? And so let me answer that question in the general. Yes, I mean, there's many things that you can do under Delaware corporations. You can merge them. You know, multiple corporations can merge into one. We do it often with our 55 and plus communities in Newcastle County because it's a service corporation and a maintenance corporation. In this particular one, I think this question is going the opposite way, which means to separate them into multiple sections. So let's take a neighborhood and do we want to divide it up into sections? Anything is possible. We don't see that too often because of the difficulty in it, but it can happen just as in condominiums. You know, when they get to a certain age, if all the owners get together, they can decide they want to recondition or redevelop their project by essentially all the condominium owners getting together and voting to have the building taken down and rebuilt in a new way. So yes, almost anything is possible. What I find your major prohibition is whether or not you actually get enough owner votes to accomplish those types of things, because sometimes you need a unanimous vote for one of those situations. Sometimes it's a lower threshold. All right. I think that's it. There's no other questions that have come in at this time. Anything else in the room? Great. Well, I want to thank everybody. And I guess, Ryan, I'll throw it back to you for the exit script. Thank you.
Thank you, Chad, and thank you everyone for attending today's webinar, Top 10 List for Delaware Community Associations, Part 2. If you have any other questions, please contact Whiteford, Taylor, and Preston. On behalf of Whiteford, Taylor, and Preston, thank you all for joining us today, and please have a great rest of your day.